there can be standards prescribed for those unique purposes, and there are across Canada, provincially, municipally, for sewer use bylaws, for example, and federally. But even where there are not specific regulatory standards in provinces, territories, or the federal government environmental statutes in Canada, that doesn't mean that PFAS compounds aren't regulated in some way, shape, or form. And frankly, what I think we really want to impart to all of you at the start of this presentation is kind of like the fundamental basics of environmental law and our provincial and federal environmental statutes that can, through their pollution prohibitions, as we call them, actually more broadly, indirectly apply to PFAS compounds, and always frankly have and will continue to do so, even where we do not have regulatory specific standards relating to PFAS in certain provinces. And by the way, what the heck is a pollution prohibition? We'll give you a couple of examples shortly, but they're really the fundamental backbone of our environmental law in Canada, both provincially and at the federal level. And then again, like I said, in municipalities with certain bylaws like sewer use bylaws. And these prohibitions can give rise to penalties, can give rise to enforcement actions. Generally, when we talk about regulatory liability, you've heard us say this many times if you've seen us present, we're talking from the regulatory perspective about orders and about prosecution. So we'll speak to some of that when we go through some of the cases later on in the presentation. So this is a really good glimpse on the first slide of how pollution prohibition, well, first of all, what the heck they are. We've just narrowed it down to 2 different provinces in Canada to make it really simple, but we've also chosen Ontario and Alberta because frankly, they're fairly similar in nature. Ontario's Environmental Protection Act and Alberta's Environmental Protection and Enhancement Act are quite similar in the way they're structured. Both the first row, the pollution prohibitions themselves, thou shalt not discharge into the natural environment a contaminant or release or a substance that may cause an adverse effect, or in the case of Alberta, significant adverse effect. Those are pollution prohibitions, and they both are quite similar. As you can see on the slide, we've highlighted in bold the defined terms and the key terms within those pollution prohibitions, but generally they say the same thing. And then in addition, we have reporting obligations. So where you have a pollution prohibition, almost always in Canadian law, you have an accompanying reporting obligation where you have a discharge or a release or an emission or a spill of a contaminant or a substance or a deleterious substance or a material. I mean, the sky's the limit, different language, but it's all kind of the same general pollution prohibition that applies and reporting obligation that applies across the country in our environmental statutes. So just really quickly on Ontario, we have actually 2 in Ontario reporting obligations. One is for discharges, the other is for spills. Spills, for brevity's sake, we did not include on this slide, but spills are slightly narrower than discharges. They have to come from a container or a vehicle or a structure, and the definition of pollutant that gets spilled is slightly narrower than contaminant that gets discharged. Having said all of that, the point is that discharges, spills of PFAS-related compounds to the natural environment may A, be prohibited, and B, be reportable to the regulator. And for example, in Ontario, that's even in the case where we don't have Ontario-specific standards, regulatory standards relating to PFAS, neither in our site condition standards in Ontario, nor in our excess soil quality standards for excess soil and fill in Ontario, for example. Alberta, likewise, very similar, like I said, to Ontario. EPIA, Section 109, subsection 2 states no person shall release or permit the release into the environment of a substance in an amount, concentration, or level, or at a rate of release that causes or may cause a significant adverse effect. We can go to the next slide, Jackie. This slide just has some of those defined terms, just so you can see how they work. Just one back, Jackie, yep. In terms of contaminants and discharges and how they're defined in Ontario's Environmental Protection Act, but also Same thing with substance, which is like a contaminant under APIA in Alberta, and release, which is like discharge under APIA in Alberta as well. So again, that's really the take-home message, and I think that kind of underpins what we're going through today when we look at the cases we're starting to see in their infancy in Ontario and elsewhere, Quebec, and federally in Canada, but also how this might all shake out in terms of case law and liability now that we are actually starting to see some regulatory standards developed, some guidance, but actually legal codified standards as well, so far in 3 of our provinces. So I'll turn it back over to Jackie to go through what I just said. Where are we at with standards and select standards and guidelines in Canada? Jackie.
Great, thanks, Matt. So as Matt said, we just have a couple of tables here that shows a summary, very high-level summary of some of the legal standards and guidelines across Canada. So our first slide is the slide shows PFAS standards in BC, Alberta, and Nova Scotia, and these are 3 provinces that have developed standards. They aren't exactly equivalent. For anybody who's a chemistry person, have a look at the units of measure, but it does give you an idea of the allowable limits in different jurisdictions for drinking water, soil, and groundwater situations. These regimes are pretty complicated and certainly beyond the scope of this presentation, but if you're working in any of these jurisdictions, you're going to need to be aware of the regime and understand how they fit together. The next slide just shows some guidelines across Canada, more broadly, Ontario and Quebec also included. Same, standards, the units of measure are not equivalent necessarily, but really they're just to show the maximum allowable limits in certain areas. There have been some concerns raised about whether some of these lower, more stringent guidelines are practical. In particular, the new US EPA guidance of, I believe it's 4 parts per trillion for PFOA and PFOS, and whether, that triggers further testing. Some commentators have suggested that that level is likely higher than even background, given the ubiquitous nature of PFAS. There has been some very recent updates about PFAS in the US. In particular, last month, the US Environmental Protection Agency designated certain PFAS as hazardous substances under the US Comprehensive Environmental Response, Compensation, and Liability Act, also known as CERCLA or the Superfund Act. And on April 19, just last month, the US EPA issued a pre-publication final ruling and enforcement policy about PFOA and PFOS, so PFOA and PFOS. And in this rule, the EPA designated those 2 substances as hazardous substances under CERCLA, which will have significant implications on remediation requirements, property transactions, reporting obligations, and even transportation of these PFOA, PFOS containing materials. Not to mention, CERCLA is a liability type statute, so it does open up perhaps a bigger range of sites that will be covered off as CERCLA or Superfund sites. And designated these 2 substances as hazardous substances will allow all levels of government, as well as private parties in the US, to use CERCLA to pursue those parties that currently own or operate, or formerly owned or operated, or sent or transported PFOA and PFOS containing materials to sites that eventually become contaminated. Facilities will also become subject to release reporting requirements based on these concentration levels. And as more companies that ship items containing these contaminants will be subject to more stringent transportation regulations. We don't practice in the US, so any more information about CERCLA, if you're working in that jurisdiction, I think you probably need to reach out to an environmental lawyer in the US to learn some more. But equally, there are both state and municipal regulations that are being established. I know California is quite at the forefront of that process. So if you're working in the US, certainly reach out to those who practice in this area for some more guidance. I'm now going to turn it over to Anand to introduce us to a few of the cases that have occurred so far in Canada.
Yeah. Thank you very much, Jackie, and nice to have everybody. Jackie and Matt were very kind. They let me kick off into the litigation part of the presentation, and I think that's certainly a lot of fun. Maybe not for the parties involved, but just to give you a kind of a real life example of how does this actually play out and what are some legal liabilities. And as Jackie mentioned, we're just starting on this litigation path in Canada, and so Jackie, if you wouldn't mind advancing, we'll start with the first case, which is Egan. And Egan is a case out of Ottawa. The Egans own a home, and they're part of a little community close to the NRCan Research Center outside of Ottawa. And so this is a class action lawsuit. And for those a little bit familiar with litigation and class actions, a class action lawsuit doesn't just go right to its merits. There's a threshold step where there has to be a motion to certify a class, and the court has to consider, is there a specified class, and is there an issue that that class shares together. So the decision that's cited on this slide is a motion by a set of plaintiffs to certify a class alleging that NRCan had allowed PFAS to enter into the surface water and groundwater. And this site was its National Fire Laboratory site. And of course, the allegation, as you can probably imagine, was that this material entering surface water and groundwater was then migrating to these adjoining 69 adjacent property owners. And that's what the class was all about. And so the class sought damages for loss of value in their properties, obviously caused by this contamination of groundwater. And then some of the members of the class also sought damages relating to contamination of groundwater. And so that may also then affect stigma attached to their property values. There's a complex nature of this claim, and the court certified the claim, and that's what that 2021 decision is, for almost all of the issues sought. So there's a more to come as to how this piece of litigation plays out. But there's an example in the civil world, and I mean private lawsuits, there's no regulator involved here, about loss of value, migration of contamination, PFAS contamination in soil and groundwater, as an example. The second case shown is Groupe Marcel, and in this case, it's actually a two-parter. So back in, well, it resolved in 2022, there was an application by Groupe Marcel and David Cape, an individual, as it related to an environmental protection and compliance order. And so that was a federal order issued by Environment and Climate Change Canada. And that order directed the orderees, who then became applicants in the case of litigation, to carry out a series of measures. And one of those measures was stop marketing cosmetic products containing, I hope I get this right, perfluoronyl dimethicones, so a specific PFAS substance. And the order also required them to recover the cosmetic products that contained that substance from their distributors and destroy them. As you can probably imagine, the company and the individual sold markets in the beauty industry, skincare products, makeups, perfumes, and this particular substance, its main function was related to waterproof and longevity of the application of the substance. So the applicants appealed the order, and that appeal goes to a body known as the Environmental Protection Tribunal. Again, we're at the federal level. And ultimately, the tribunal confirmed the order, found that it was reasonable in the circumstances and consistent with the protection of the environment and public safety, whereas the measures that the applicants were proposing were not. And so that's the first decision in the kind of first grouping of bullets. But the sub-bullet is kind of the follow-up, and this is very recent. This is as of 6 weeks or 2 months ago, where separate and apart from that Groupe Marcel was charged and convicted because it was marketing these cosmetic products containing the perfluoroanyl dimethicone, and that is considered a new activity, and that's a defined term under the Canadian Environmental Protection Act 1999, or CEPA. And so CEPA requires a person or company to provide certain information to the government where there is a new activity that could pose a risk. And that's where the government prosecuted where that information as it related to perfluoroanyl dimethicone wasn't provided, and it was being used, marketed, and sold in Canada without that information provided. And you'll see on the screen that there's a $500,000 fine that is ultimately levied against the company. And similarly, the products that contain the substance had to be withdrawn from the distribution chain. So the first example was a little bit more local, soil and groundwater. The second example deals with a little bit of the import, the manufacture, the use, the sale of products containing PFAS in Canada. How about on the regulatory side a little bit? So the third example is a great example of how Matt described different and long-standing regulation of PFAS, notwithstanding the lack of a particular standard. And so in this case, this is out of Ontario, where St. Mary's Cement is a company. It operated a cement manufacturing facility, and in Ontario you have to operate pursuant to an environmental compliance approval in certain circumstances, this being one of them. And that environmental compliance approval, or ECA, requires you to apply for certain, provide certain reporting in your application, and then sets out very specifically what you can and can't do, very similar to an APIA approval in Alberta for those who work out in Alberta. To make a long story short, there were a series of amendments to this company's particular ECA, and the most recent amendment related to increasing the approved maximum consumption rate of alternative low carbon fuels at the facility. And what's interesting here is that the municipality in which the facility was located, Clarington, shown on the screen, objected and, in fact, sought leave to appeal, which means sought permission to appeal the company's amended approval. And the municipality had a number of concerns, including how the Ministry of the Environment's director that was acting in this circumstance, didn't fully assess all of the alternative low carbon fuel types, and there were concerns associated with emissions. But one of the things that the municipality raised in argument was that the ECA should have imposed conditions enforcing stringent standards and prohibiting the use of dangerous materials, including those containing PFAS or PFAS compounds. And so, you have a municipality trying to include in a regulated entity's approval standards relating to PFAS. And ultimately, the municipality wasn't successful. The tribunal found that the municipality wasn't able to make, in law we call a prima facie case, a kind of a good start on the case. And then there's a high legal test that has to be met in this circumstance. So ultimately, the application for leave to appeal was dismissed. But these three examples, I'm going to turn it over to Matt for the last one, just give you a sense of how we're approaching this issue from a bunch of different perspectives. Matt?
Yeah, thanks, Anand. So last bullet on the slide, the fourth case on this slide, is more closely related to the actual 5 cases, all within one tribunal that Jackie's going to take us through shortly. But this particular case is at a specific tribunal in Quebec. So what happened in this case, and this relates to human health as opposed to strictly the environment, whereas Egan relates kind of to both, Groupe Marcel, frankly, to both, and then Clarington much more, well, it's always both, but environmental law more so with Clarington. This case is much more so about strictly human health, as are the 5 cases that Jackie's going to go through. And in the Desbiens case, the 4th bullet on the slide, what happened here was Mr. Francois Desbiens had worked as a firefighter for the city of Longueuil Fire Department in Quebec since 2006. And then, lo and behold, unfortunately, in 2019, He was diagnosed with testicular cancer, which he believed was linked to his exposure to halogenated flame retardants in his work environment. Those retardants obviously containing PFAS compounds, hence we've included this case in our presentation. And so he filed a complaint with Quebec's, quote, Commission on Standards, Equity, Health, and Safety at Work, end quote. That's the English translation. And his claim was rejected. So then he went through the appeal process, contested the commission's decision, and appeared before what is known as the Administrative Labor Tribunal in Quebec. And Mr. Desbiens testified that throughout his career, when he was putting out fires and using these compounds, which were really Class A and B foams, mixed with hose water to put out the fires, those were, and through the literature, through what he could put forward through his case, representing a new emerging class of carcinogenic chemicals believed to be specifically responsible for, in particular, reproductive cancers like testicular cancer. And the tribunal ultimately held that Mr. Desbiens did suffer an occupational disease that was a result of his work. And he was exposed to carcinogenic contaminants, at least one of which is recognized as likely to cause testicular cancer, quote unquote. So the tribunal determined that from a biological human health point of view, there were mechanisms that explained that development of the cancer following his exposure to those PFAS compounds, and that the medical literature demonstrates a high incidence of this type of cancer among, in particular, firefighters like Mr. Desbiens. So I'm going to turn it over, like I said, to Jackie, and she's going to take us through 5, not related specifically in terms of the people who are involved, but 5 cases that are all before the Veterans Review and Appeal Board, some of which are fairly recent. Jackie.
Thanks very much, Matt. So in Canada, PFAS-related claims are becoming more prevalent, certainly before the Veterans Review and Appeal Board. And in this slide, we have 5 recent cases, 2021 to 2024, just this year, that relate to PFAS health and occupational-related claims before the Veterans Review Appeal Board. And the first one is filed by a firefighter who served in the military, and he applied for disability benefits for non-alcoholic liver cirrhosis, and that claim was denied. He appealed it to the VRAB, and he noted that the board noted, that providing the relationship between the illness and military service was a key issue. And in the applicant's statement and testimony, he set out that he had been exposed to chemicals during his 33-year military service as a firefighter, in particular, direct and regular exposure to aqueous film-forming foam, or AFFF, and carbon tetrachloride, which medical evidence indicates can cause liver disease. The board found that it was more likely than not, that was the test, that the applicant's illness arose out of or was directly connected to his military service as a firefighter, and he was granted 5/5 entitlement for his condition. The next case, also a service individual. He served in the regular forces from 1986 to 2006, and his request for benefits was denied at the early level, the Veteran Affairs level, and he was claiming a condition of ulcerative proctitis under the Pension Act. And in his claim before the board, the applicant submitted evidence that had been accepted, that he had been exposed to aviation fuels during his service duties. The applicant also submitted medical opinions in support of the link between occupational exposure to aviation fleet fuels containing PFOA, and organic solvents containing methyl ethyl ketone in the development of his ulcerative proctitis. At the appeal level, he was successful and granted entitlement. The third case was a situation of an individual who served in the reserve force from 1972 to 1974, just a couple of years, and then he moved into the regular force from 1974 to 2001. And he originally applied for disability pension for adenocarcinoma of the prostate under the Pensions Act, and this claim was premised on his work with radar and high frequency radio waves during his service. He also claimed that he had been exposed to AFFF used in firefighting during that service. In this case, the applicant submitted articles about the exposure through AFFF products to the board, as well as one of the earlier decisions we just mentioned in terms of supporting his claim. Interestingly, the panel held that there was no evidence that the applicant had been significantly exposed to AFFF such that it was considered harmful and related to his condition. The review board also said that decisions of the Veterans Affairs Review Board are not binding on the first level panel, and that the decision that was referred to was not sufficiently similar to this case in order for it to have any precedential value. The panel found that the condition of adenocarcinoma of the prostate did not arise out of his service involving the radar and ultra high frequency radio waves. The next case also originated at the entitlement tribunal and was a denial of a claim for ulcerative colitis under the Veterans Wellbeing Act. And the applicant brought his claim before the reconsideration panel, including providing new evidence consisting of a medical report that pointed to the probability supported by expert studies of a link between PFAS exposure and the claimed condition. He also presented an Ontario public health document on PFAS, and the panel ultimately awarded entitlement to those benefits that had been denied. In the final case, this is brand new, 2024, an original VAC decision denied the veteran's application for pension entitlement related to bladder cancer, and that the applicant attributed to his exposure to various environmental hazards during his service. During his service, he was involved in extinguishing simulated aircraft fires with AFFF. And in support of his claim, he submitted a medical opinion from his urologist confirming that bladder cancer is associated with environmental factors. He also submitted an article from the American Cancer Society on firefighters and increased cancer risk. He also provided several other documents that related to ongoing lawsuits in the United States where AFFF was found to be toxic and carcinogenic. The panel did determine that the bladder cancer suffered by the applicant arose from his military service, and his entitlement to pension benefits was instated. So in Canada, we're seeing a wide variety of different types of PFAS litigation, albeit not very many, both regulatory and in the civil context. We're only aware, as Matt talked about, of one, it might have been on it, pardon me, of one civil lawsuit case, Egan, but there are a number of other regulatory and administrative law decisions in Clarington and Desbiens, about orders and prosecutions and Group Marcel. And then we're seeing a number of human health cases in the Desbiens and the Veterans Affairs appeals. And as we've seen with the Veteran Affairs proceedings, a real issue that arises is causation and the need to prove that PFAS caused the injury or harm that's claimed. And we've seen, and in the US, there's certainly been evidence that a general claim that PFAS is harmful or that you can be harmed if you're exposed to it is not enough. You need a more specific causal connection. And while we're not seeing the number of cases like in the US, and I saw Josh posted a comment that there's more than 15,000 claims being made against DuPont alone, we're not seeing that level of claim in Canada as yet. But what we are seeing, and which I think will follow from the US, is that now we're seeing US cases that are being made against other people or other entities. We see claims against the manufacturers of products that contain PFAS, but we're also now seeing expansion in the US to claims against state and local governments for not taking action, or state and local governments suing manufacturers for causing contamination that the state or local government is now required to address, and most often in water, drinking water contamination situations. We're also now, there are a few cases in the last year or so where individuals are suing the companies that have used products with PFAS in delivering their own services. Think of those companies that use food wrapping and packaging that contains PFAS, or those companies who are creating and selling rainproof or waterproof clothing, and those manufacturers. So we're seeing an expansion in the US of the people who are being sued or the entities being sued. And while Canada's not there yet, we're likely going to follow suit in many different respects, not just in terms of litigation, but also in terms of movement in creating standards and guidelines that will need to be followed. So we're going to conclude the presentation portion of today there, and we want to be able to have some time for Q&A. So maybe I'll turn it to Josh. I'm going to stop sharing, and we can turn it to Josh to deal with some Q&A, or maybe Andrew. I'm not sure who's going to direct us.
Either one of us is fine.
I'll jump in. Yeah, those that are in the chat, we've got about 211 people. If you've got questions, kind of fire them off in the chat, and we'll try and get through as many as possible here. But I'll kick off. And you know, one of the biggest reasons I wanted to host this webinar series is, and I've said this to a lot of people, which is the market is split, and not split in terms of 50-50. It's split in terms of there are customers that we have across the board here that have dealt with PFAS for a really, really, really long time, and those that haven't. And talking to people from east to west, you know, there's certainly a feeling of like, I kind of don't want to look at this because I'm afraid of the unknown. You guys have any, I'm not going to say advice, but thoughts on test or not test for PFAS compounds, and kind of what factors play into that role of that decision making?
Yeah, that's a great question, Josh. And it's not advice, but we're going to speak to just some factors, I suppose, off the top of our heads, and what we've kind of experienced and talked about internally for sure, and with clients on specific files. I'm happy to go first, Jackie, on. And look, the obvious first piece to this is, do you have a regulatory standard? So in the provinces in which we so far have regulatory standards for prescribed purposes, you know, that's your first, I guess, checklist item, where you look at that and say, okay, for this purpose, REMCERTs in Alberta, for example, we need to test in this situation for this project. So that's the easy first point. But what if you fall into the bucket of there is no prescribed standard for that purpose that you're looking at? And here's a really good example: transactions. So, you know, what our firm gets involved in with other firms who convey land or you know, shares of companies or assets and what have you, is when we're involved in transactions, we help to steer, along with the environmental consultants and the labs and the contractors and so on, the team helping whoever it is, whether you're the seller or the buyer, to navigate your risk. And it's different risk, and there are different factors that come into play if you're buying versus selling. So if you're buying, the first thing that we always say to all of our purchaser clients is know what you're buying. So there's way more of a potential likelihood, if you have access granted as part of the deal, for example, that if there was some historic or there's some current use that may give rise to PFAS contamination, that's a factor, and that's something that maybe the purchaser wants to see if they are able to, again, with consent and access from the seller, test for. Soil and groundwater, standard pre-purchase due diligence on a commercial industrial site, but maybe including PFAS compounds in the suite of analytes to be analyzed by the lab, for example. And it might be different from the seller's perspective, and maybe the seller doesn't want to know. And these are some of the transactional kind of thought processes that happen between seller and buyer. What else? I mean, just in the excess soil or relocation of soils context. And so we have obviously some laws in provinces in Canada now, in BC and in Ontario in particular, and also in Quebec with tracking related specifically to fill and excess soil, new regimes. And, you know, there may be differing factors and thought processes there, whether you're the source site or you're the receiving site, or what's in your approval if you're a landfill, and what are you required to have tested for before you can accept soil. You know, reuse site owners who know that they're getting soil from a, you know, from a site that may have historically or still currently does have uses that may give rise to, through the assessment of past uses or a phase 1 ESA, PFAS compounds may want that testing done, even though it's not actually in the excess soil quality standards right now, the generic standards. That's another factor that, you know, can play into things. So those are the types of things that we consider when we're advising clients, but it kind of depends on the objectives of the client and the objectives of the project, and also, again, looking at what were the historic uses. And just this is just a factor, but doesn't really help anybody. And this is exactly your point, Josh. The problem with this stuff, as everybody on this call knows, is that it's so ubiquitous just because of historic use for decades. So you run into that issue, which is so complicated and poses a lot of different thoughts and perspectives on to test or not to test. But I'll just leave it at that. That's kind of an unhelpful last point. But yeah.
Well, but it's a question that the marketplace really brings up, that, hey, if it's everywhere, we're going to find it. What do we do?
Exactly.
Yeah.
It's a tough one. And so at least, you know, if you're dealing with firefighting foam or you're dealing with chrome plating or something like that, that there may be a chance, if you can historically look at the operations, that there's more of a chance that you have an actual source on site or nearby. You know, that's a driver for sure. So it's tricky. Jackie, I don't know if you have any additional thoughts or on. And
Yeah, just on what Andrew just said is that, you know, ubiquitous, yes, background is probably there. But as you go through and you look at a standard process for assessing an environmental, a site that may be contaminated, you're going to look at historic uses. So if your property has never had a fire, so no AFFF. Your property is not a metal plating facility, never has been. Your property doesn't, what else? Use rubber manufacturing, doesn't have aviation fuel, whatever potential sources of PFAS chemicals are, then you're able to assess, okay, yeah, we might find it, but maybe we don't sample for it. I mean, if you think of a gas station, well, maybe that's a bad one. If you think of a dry cleaner, you're probably going to search, if it was a PERC plant, you're probably going to make sure you sample for PERC. You may or may not sample for PHCs if you happen to use an alternative fuel, or sorry, an alternative solvent. You're probably not, although maybe, going to sample for PFAS, except now PFAS has been in clothing and waterproof clothing that may get washed through the dry cleaning process, and now is that now contaminated? So these are all no good answers, but all the factors that you're going to have to consider as you're assessing a site and what environmental information you need. And I know Anand probably has a follow-up on this for us.
Well, I'll try to put a bow on it. I think it's just being thoughtful, right? Like I think if you're gonna kind of say as a blanket, I'm gonna ignore the topic. And Josh, it sounds like, you know, maybe that's been a little bit of the approach in the past by some. You know, I'm just not touching it. I'm just putting my head in the sand. No, you know, kind of no pun intended. I think that's likely going to expire as a valid line of thought shortly. There may be a thoughtful reason why to not test for PFAS in a specified scenario, but I think otherwise you're probably just kicking the can down the road on a potential issue.
Yeah, I mean, what we have seen from a laboratory standpoint in the last, call it 12 months, is, you know, there aren't massive PFAS projects in Canada. What we have seen is the rise of it incrementally as a function of people going, I'm going to look at 1 or 2 samples within the site, but that's happened across the hundreds of jobs we receive from east to west daily, and that has been basically the domino that has increased PFAS testing across. I'll turn it over to Andrew for a question, but I do have one statement as well, which is, I know we talked about wildfires and firefighting foam. What's really interesting is BC, the region most hit with wildfires, on their government website, they actually talk about the foam and has an explicit statement around their foam does not contain PFAS, which is very interesting. Talks about its influence on drinking water. So just an anecdote there. Andrew?
Yeah, and I think you guys sort of touched on it, and the question we get a lot is, okay, what's next? When are the regs coming? When are things happening? And because we, you know, what happens in the state, it's so well televised and in social media and things, and so everyone's sort of in great anticipation of what's going to happen in Canada, and when will Health Canada guidelines come out, and so what do you guys sort of see as the next 2, 3, 5, 10 years of the evolution of Canadian PFAS?
Mm-hmm.
Yeah, so Matt and Jackie, I'm happy to offer a thought, but please jump in. I mean, so I think a lot of the world has followed developments in the United States and Europe. I think that's a good starting point. And so as that development continues and that science continues, and that's not exclusive to those jurisdictions, but as that science is borne out in different jurisdictions, I think we can expect that to be both independently studied in Canada and then picked up by our regulators. Then, so that's one driver. Another driver is continued enforcement by, I'm going to say, not the policy branch of government, but the kind of investigations or inspections, investigations, and enforcement branches, kind of the boots on the ground. And that's going to start to continue to drive day-to-day enforcement based on laws that already exist. And that increases the pressure, increases the awareness. Then you add the private disputes, that grows kind of the administrative litigation that Jackie and Matt expanded on, especially right now we're seeing it by chance at the Veterans Appeal Board, but you know that all builds. And so, Andrew, I think we're in a state of flux. Like it's hard. It's hard to keep it's hard for us to keep up with, even on the legal side, the kind of continuing changes in regulation across multiple jurisdictions. But I think what industry will demand and the public will demand is certainty. Like, we got to set the playing field somewhere, appreciating that could move. My view is that, pick your time horizon, 2, 3, 5, 7 years. I don't know what the right number is, but we're probably going to need some certainty from which to work. But Jackie, Matt, welcome your thoughts on that.
Yeah, I've two kind of additional thoughts. I think what the U.S. has just done in terms of PFAS and CERCLA will be a game changer in the U.S. And certainly it's going to create perhaps some more pressure in the U.S. to deal with PFAS. I mean, we know there are tens of thousands of lawsuits, but having the CERCLA identification of hazardous substances is going to impact. I think, though, public pressure. I think, you know, there may be a bit of a sentiment out there, and Josh, we talked about this.
Oh, no.
I know.
A little bit. We have cases that say it does some seriously bad stuff, you know, and I don't mean to minimize it, but cancer, cirrhosis of the liver, you know, there are real implications from a health perspective of PFAS. And as recently as I think it was May 13th, there was an article, I'm going to get this wrong, it was either CTV or CBC, where they were talking about North Bay, where the military base up there had been used for firefighting, training, and other elements, and AFFF, PFAS had gotten into the drinking water, and just as recently as days ago, there's a media report about PFAS and the issues that surround it. So I think that's going to continue. That public pressure, media is going to continue to drive us to get better science, like Anand said, and develop better techniques for testing, analyzing, and then remediation. And I know that's a whole other topic that you guys are going to have as part of your session, but the remedial technologies that are out there, I mean, we've got to find some stuff that works, because this stuff is everywhere and it's persistent and it's going to be around for a while. So that would be my just sort of add to what do we predict in the next number of years.
Yeah, so there's two questions in the chat. Andrew, I don't know if you want to grab the first one. I'll have a comment about the second one. And
the second one, sure.
Yeah.
Yeah, Toby has posed, is there a PFAS source list existing, much like the PCA table, in Reg 153? I mean, from a lab perspective, even the moving target of PFAS as a class and how many compounds and which method is challenging, but maybe you could speak to that.
I can start with a non-answer. Toby, good comment for sure. Like, and obviously the PCAs in that regulation, which is the record of site condition reg in Ontario, were developed probably with a lot of scrutiny and thought by the ministry and roundtables and so on, just like excess soil has been for the generic standards. So it's a tricky one because, and thankfully, Jackie, Anand, and I don't need to worry about this stuff because that's for the smart technical folks who are all of you. But if there was a way to discern it down to those kinds of lists like they have in that schedule in OREG 15304, great. My only, I suppose, question that I'm posing, because I'm not being helpful, is that even possible given the nature of PFAS and how broad it is, and talking about tens of thousands of different potential compounds, and how the labs are doing all of this analysis with the different, I've learned a little bit about, the lab's different processes and protocols and what catches certain compounds and what may not, and so on. It's a nightmare scenario. So I just feel like it's not as simple as at least the PCA table we have in Reg 15304 for your more, standard contaminants that we're regulating here in Ontario and elsewhere across Canada, for example.
Yeah.
It's a great point, though.
Yeah, it's a great question. Let me pick up on it from an American lens. And so we do, lots of work with companies who have American operations and Canadian operations. And so those are great files to try to compare and contrast kind of the approach on different sides of the border. And so I was speaking with one environmental lawyer, kind of my counterpart for this client in the United States. And she was explaining how, given the recent CERCLA designation that PFAS are defined as hazardous substances, and that's what Jackie spoke to in about the middle of our presentation, that triggers, under the US versions, we call our CSA standard for a phase 1 environmental site assessment, a due diligence style review. The ASTM version ties what you have to consider to what CERCLA designates as a hazardous substance. And so all of a sudden, the potential use of PFAS has to be considered on any given site. I'm not suggesting it will become a potential contaminating activity on a given site, but that, Toby, goes to your question, right? Like, how are you going to make that link between site history and is this a concern on site? And it's that's a gap for sure.
Okay, so we're running out of time here, but I'll get into Amelia's question about, the elephant in the room is there's PFAS in unknown places and chemical patents. So I guess this is more this is 100% opinion. And we've seen this in other cases, you know, just citing the one around makeup is, I think where the future is you are not going to be able to plead ignorance anymore, right? We're seeing it in certainly on the US side, people are going where people's products are going, it's not my product here, right? In my clothing, it's the manufacturer's fault. And somewhere along the way is going to have to face that burden of ensuring that those components, and to be clear, like, yes, PFAS is everywhere. And yes, we're not going to eliminate it. All we're trying to do is reduce it as much as humanly possible. And you're seeing this in, I think, the California regs is like, yeah, you can't claim unintentional use anymore. So I don't know if any of the three of you have an opinion on question number 2 there.
Well, and if I may, sorry to monopolize a little bit, but I was on a call with a U.S. client yesterday afternoon talking about like exactly this. And there's currently proposed amendments to regulations under SEPA at the federal level surrounding the use, sale, manufacture, and import of substances, including containing PFAS. And the current law provides an exemption for incidental presence. And the proposed change is, although keeping the concept of incidental presence in, allocating that incidental presence is 1 part per million of PFAS. And collectively, you know, appreciating that we're talking, as Matt said, about tens of thousands of different compounds. And so that's absolutely a huge concern. The question's great, Josh. I like your answer as well, right? Which is, we may be forced to test everything. And there's a, you know, that would be a pretty broad change to the current approach, which is, well, it's not an additive. I'm not making a Teflon pan. I'm not looking to, you know, increase the longevity of my skincare products by using these additives, but we're going to start to perhaps see the scope increase to everything. And I don't know about hydraulic fracking fluids myself, but that could be something that gets caught into that type of law.
Josh,
Yeah,
I want to jump in on one thing that you said. So you can't plead ignorance. Ignorance of the law has never been a defense. So that's where, you know, to Anand's point a little bit earlier is ignore at your peril in some respects, right?
Just as you were speaking, my last thought is PFAS just the tip of the iceberg? As technologies evolve, we can test for more parameters. There's new emerging compounds. Like, are we just at the beginning of this apex of testing for everything, everywhere, all the time?
Yeah, maybe. Yes.
Yeah.
I mean, even think of, I know someone had a comment about, you know, is this just shining a light on another thing? I mean, think about the contaminants we already deal with, you know, perchloroethylene, it's been around forever. 20 years ago, we didn't really think too much about it. And 50 years ago, we dumped it out back and it would volatilize. So it's no, you know, these maybe are truly more emerging contaminants, but as we learn more, as we can do more, as we can test more, we're going to have to.
So we should book this call for 5 years again for now, Josh.
Yeah. We'll close out here. We're at the kind of top of the hour. So thanks everybody for joining. You know, it is our absolute intent to continue to have sessions like this. We'll take a break in the summer, and then we'll come back with a new series, unconfirmed whether it's PFAS or not, but we want to continue to educate because we know a lot of these discussions happen at conferences. Unfortunately, it is extremely expensive for most people to get access to the information, and that's our goal, is to just make sure information gets to the general public, especially this group, because the liability as an environmental company lies within us to lead by example. So that's the goal here, and thanks everyone for their time.
Thanks very much. Have a good day, everyone.
Thank you very much.
Thanks, guys.